What this judge said in LBRY, Judge Torres could read it and she could think, well, he makes a good point here. Oh, that's terribly flawed reasoning where he says it doesn't matter if the promoter says anything or goes away, it still could be a security. Judge Torres could have the same exact reaction that John Deaton's having, which is to be like, that is the most deeply flawed reasoning I've ever heard. Why is it the most deeply flawed reasoning? Because in 76 years of case law, ladies and gentlemen, not one time in the history of the United States from the Supreme Court since 1946 until today has there been an investment contract found when there is absolutely no connection whatsoever between the purchaser of the token or the asset and the seller. And when there is absolutely no connection, i.e. I've never heard of Ripple, don't know what they do with things. I like this token. It works well on the ledger. I'm going to buy it. When there's that kind of situation, it doesn't apply. It's not an investment contract. So don't let this LBRY case get you down and think, oh, doomsday is here. Where I just simply said, no precedent supporting his theory. By the way, the SEC was relying on expert number one who was going to get in our mind and say, this is what an XRP holder thought when he bought or she bought XRP, right? He was going to say all those things. But what happened? XRP holders challenged him. We filed an amicus brief, or a request for an amicus brief. Ripple challenged him on a Daubert issue. What did the SEC do? They backed away because at his deposition, he said, oh, I didn't know all that. Had I known that the XRP ledger, you had this utility about it and that people could actually use the ledger itself and get on the decentralized exchange and it was being used in MasterCard and Visa and Uphold and all these other creds as these cards as a substitute for fiat, I didn't know that. And maybe I would change my mind. So they rescinded that. Then we get into how we get into what wasn't involved in the LBRY case. I cite to the judge the XRP debit card from Uphold, from the other cards that are being offered, the fact that people are getting paid in it. Here's another thing that doesn't apply to the LBRY case. Over 5 or 6 jurisdictions across the world have declared XRP a non-security. You've got the United Kingdom, you've got Japan, you got Singapore, you got Switzerland, you got the United Arab Emirates. Okay? It keeps going on. You got all of these countries who looked at XRP and said it is a legitimate form of currency, medium of exchange. That does not exist in the LBRY case. All right, it's not even apples to oranges. It's not even fruit when you're making the comparison. Okay, and so we go into all of that. Also, that's not in the LBRY case. Spin the bits, tap jets, right? All of these companies are saying, look how we use this asset in a way that doesn't involve Ripple. And so there's no reason to lose confidence. Let me tell you, this decision in LBRY sucks. This decision in LBRY, if I would have told the SEC to write the opinion yourself, they wouldn't have written it any better for them. Let me just be candid. But it is ultimately going to sit in the realms of history as a federal judge sitting in New Hampshire who followed case law that's not applicable where we're at in the Southern District of New York. Last thing I would want to comment on, what else doesn't apply in the LBRY case that applies to XRP? Well, a couple things we go over in our XRP holder amicus brief. 2014, the Government Accountability Office described XRP as a virtual currency in a decentralized payment system. 2015, the CFTC said Bitcoin and similar cryptos are commodities. In 2015, FinCEN settled with Ripple, declaring XRP virtual currency that forced Ripple to comply with the banking laws, not the securities laws. 2019, the framework that the digital asset framework for the SEC says this. It says a cryptocurrency that can be used immediately for payments or as a substitute for fiat is most likely not going to satisfy Howie. Can you think of a crypto that is used in immediate for payments and as a substitute for fiat? Can you think of one better? Well, guess what? In the Tap Jets amicus brief, they put in their survey where XRP killed all the other tokens as it relates to those two topics. Okay. Also, LBRY credits weren't used by MoneyGram in 2019 when MoneyGram filed forms with the SEC advising the SEC that they were going to use XRP in their cross-border payments system. Those are the things that we have that weren't in LBRY. I feel for LBRY. I tried to fight for LBRY. I tried to draw attention to the case because I knew what was going to happen. I knew that there's likely going to be this ruling for the SEC, and then the SEC would trumpet it out as though the Supreme Court of the United States had ruled, and that's just not the case. So remain strong. I'm telling you, I'm very confident that the SEC will not win their summary judgment when the judge rules.